In the general freezing order environment, the person making the application is required to give an undertaking as to damages. And there are issues for the lawyers as well that they should be, even if the judge has forgotten to ask, they should be offering it on behalf of the client. So there is an expectation because of the nature of the application and the impact it can have that you give an undertaking as to damages. It may be that a judge would not require the undertaking as to damages. I wouldn't think that's very common, but in theory you can offer the undertaking, but the judge can decide not to accept it.
Cathro Partners presents The Cut, a podcast about all things insolvency.
My name is Henry Kazar. I'm the principal of Cathro Partners in the Canberra office, and welcome to the next episode of The Cut, where we talk about all things insolvency. Before we get into our topic today, which is freezing orders, I'd like to introduce Graeme Blank, who I've worked with over a number of years in insolvency-related matters. Graeme, perhaps you could introduce yourself, and then we'll kick off.
Hi, Henry. Thanks. Yes, everyone. I'm a barrister based in Blackburn Chambers in Canberra, and I've been doing insolvency and related work and bankruptcy work for many years with Henry, and I also do commercial property, equity, and some wills and estates matters as well. So I do a range of those kinds of work.
Thanks, Graeme. Our topic today is freezing orders. Freezing orders is a very broad term. As insolvency practitioners, we from time to time are required to consider what we need to do to protect assets and preserve assets whilst we work through our investigations and proceedings that we might be considering pursuing for the benefit of creditors and beneficiaries and other stakeholders from the work that we do. It's not something that we do very often, but from time to time it is important and we need to get this right. An analogy that I would share with you that comes to my mind so that I can understand what freezing orders are about are a bit like a creditor or a shareholder making an application for a winding up order on insolvency or just and equitable grounds. And there are concerns in relation to the dissipation of assets prior to the hearing of the winding up application, which I'll call the primary proceedings. And if there is evidence in relation to potential dissipation of assets, then what we as liquidators can do is make an application to the court called an interlocutory application that seeks to protect and preserve the assets whilst the main proceedings are on foot. That's called the appointment of a liquidator provisionally. And what that person does is, subject to the orders of the court, of course, protect and preserve until the primary proceedings are heard. Freezing orders tend to mirror that type of proceeding. They are complex and they are very varied in what you can obtain, and depending on the circumstances, different evidence is required, different orders are sought, depending on what it is that you're trying to do. In seeking to explain this, Graeme and I have categorised the issues under a number of headings, which I hope will help our listeners understand what it is that we are seeking to do in these circumstances and obtain a better understanding as to the circumstances in which and the benefits of making these applications. So the categories that we're going to be talking about today are understanding freezing orders. What do they actually mean? The purpose and the scope of them. And again, that will depend on the circumstances. The framework within which these applications are made. The type of assets that are the subject of the orders. Any international issues that may be relevant if there are assets overseas, and then any challenges or legal considerations that we need to think about when we make these applications, which, if they are not made ex parte, that is, they are not made with the other party there, that we need to think about. So Perhaps we'll kick off with understanding what freezing orders are about in a broad context and start with that. Graeme?
Thanks, Henry. Well, look, a freezing order is very much an unusual application that is brought to the court to make sure that there are some assets available at the end of the litigation. So what usually happens is you'll commence a claim, you will run the claim. If you're successful, you get judgment, you're entitled to enforce that judgment against the assets of the defendant. In some situations, though, the court, if they have evidence that those assets are being dissipated or removed, can make an order to make sure that the assets stay in place so that if you're successful in your trial, there are some assets there to recover from. It's important, though, they aren't security. Just because you get an order freezing them so that they're in place doesn't mean you're entitled to access them directly. It just means there's some funds available if you're successful in your judgment.
Just occurs to me while you're saying that some of the assets that we might be seeking to freeze might be subject to securities held by third parties. What happens there? Do you need specific orders, or can the secured creditor act independently of these orders? Are they bound, or how does that work?
That's a great question. And the fundamentals of a freezing order are different from a security in that a freezing order is an order that's made against the individual, so it's made against the defendant. It's not an order that actually attaches to the asset itself. So what the court will do is they will make an order against the defendant to say you must not sell, transfer, or something else, any assets under a certain limit, and that limit is based upon the amount of the claim, plus an amount for any interest that might accrue, plus an amount for the estimate of legal costs that will be incurred in running the case. So it's not doing anything other than restricting the use of those assets by the defendant, but it isn't actually an order that in any way attaches to the asset itself, so that underlying securities and so forth are not affected. And part of the order is that some amount needs to be left available for the defendant to pay, for example, if there's a mortgage, to be able to make the mortgage payments, to pay reasonable business expenses, to operate their company and so on.
I see. And how do you determine when you're not sure of the extent of the claim? When you're in your preliminary investigations, there are a number of claims that you generally become aware of, but you're not quite sure what the extent of those claims are. How do you get to the point of determining the scope of the freezing orders that might be relevant when you're unsure about the extent of the claims that might be made?
That's going to depend on a couple of things. A freezing order is often made at first instance without the other party being present. It's an ex parte application. And the reason for doing that is if you give the other side or the defendant notice that you're going to make an order to try and freeze their assets, they may quickly move them offshore or sell them so that you can't access them anyway. So at the beginning, as an ex parte application, you must give every piece of relevant information to the court, whether it helps your case or hurts it. It's part of the requirement of such an application. So at best you can do in a situation like that is to say, this is the basis of my claim. I think I've got a claim in relation to a particular asset that's been transferred for undervalue. I think I've got directors' loans that haven't been paid, which in the company's books are set at, say, $500,000. I may have a claim to recover other assets or some other uncommercial transaction, but I don't know exactly what that was worth. And all you can do is put that to the court. You pitch it at an appropriate level to try and cover those claims as much as possible. And similarly, legal costs have the same problem. You don't know how much it's going to cost you to run the case, but you can give as best an estimate you can with an explanation of how that estimate came about. And you do the same thing for estimating your claim as well.
And normally there's a return date that would be set, and if you have further information, that's the point at which you provide that further information to the court.
Yes, and we'll talk about the process a little bit more later, but that is certainly something you'll get an opportunity to revise the figures, revise what kind of assets are being preserved and so forth.
Yeah, thank you. One of the elements that has been popping up from time to time is the type of proceeding that needs to be on foot to justify the application for a freezing order. Could you talk a little bit about that as to what we need to be doing as a prerequisite to making the application? A bit like the application to wind up, you've got a winding up order. That's quite straightforward. And then an interlocutory application for a prob-lic, we understand that. What about other freezing orders and the prerequisites to making that application?
Well, the first thing about a freezing order is that it can be made at any time. So you can make an application to freeze assets before you even commence proceedings. You can, in some cases, seek an order after there's even been a judgment, although that's much more rare. What you need to be doing, though, is you need to establish to the court that you have at least a prima facie case. So on the facts that you have, the court can see that there is an arguable case to justify considering the order. You need to identify the amount of money that's involved so they can make an order. And depending on where you are in the investigation process, how much information you need for that prima facie case is going to vary. So, for example, if you haven't even conducted public examinations yet, you may not have much information from the books and records, but you've got something. But if you then get notice that the asset is being dissipated, so the property is being sold or something like that, you can go to the court and say, this is the information that I've got, but I have some evidence that it looks like the assets are being stripped away. I want an order freezing things. And what the court will usually then do is require you to file your claim or take other steps to try and make more firm the basis of that claim and give you a certain time frame to do that. And at some point later, the court can either confirm that freezing order stays in place, or it may say, I'm not satisfied, there's enough evidence, and discharge it.
Okay, well, that's interesting then. So we don't actually need to have a proceeding commenced to make the application?
Not under the traditional freezing order regime, which is a regime that's in every superior courts, the state supreme courts and the federal court, and there are now harmonised rules, so the process is pretty similar across all of those jurisdictions. There is a separate opportunity for something very similar to a freezing order under Section 1323 of the Corporations Act. And in that one, there are a few more criteria that you have to have commenced proceedings or need to be a regulator and so forth. But as a general rule, you don't have to have commenced proceedings, but you need to still show that you've got a good claim.
Yes. And the public examination of parties associated with the entity would be considered a proceeding potentially for the purposes of Section 1323?
It can certainly be, and there are certainly decisions. There's a recent decision in New South Wales where, in fact, orders were made just prior to a public examination because of the evidence that the assets were being removed.
Interesting, very interesting. So, what does the court want to see? When we go to you and say, look, we're worried about this, we're concerned about these assets moving about, what is it that the court needs? Because often there's a lot of hearsay and scuttlebutt about what goes on, but it comes down to real evidence. What is it that the court needs to see to be convinced, even if it's an early application and you don't have a lot of information?
Well, it is going to vary on where you are in the process. So if you have, as I mentioned before, only got the basic books and records of the company, for example, you haven't conducted a public examination, you can only have a fairly limited amount of information about the claim itself. If you have conducted a public examination and other inquiries, then the court expects a higher level of proof. So what you want to be doing is providing enough information in the particular context of what you've got, but it's also important to set out what inquiries you've made, and particularly if you aren't making an application very early in the process, if you haven't made the inquiries, what you would expect those inquiries to uncover. And it may well be that the application is harder to achieve later on because the court is concerned that you haven't acted quickly to try and preserve the assets. So, for example, if there is a company and the director has a number of properties, for example, and there's not much evidence of those properties having been sold, a court is going to wonder why you're bringing an application 6 or 12 months later, because there's nothing to show that the assets are being dissipated. So you really need to be able to show the court what has changed to justify that order. So whether suddenly the assets are being sold or transferred or something like that, and have some proof of that so that the court can make its decision. But what the court's doing is on that first application, which is usually ex parte, so without the other side there, they're simply putting an order in place to hold the status quo. They will then allocate another date, usually a couple of weeks later, to give you time to contact the various people to put them on notice of a freezing order, a bank, for example, or a real estate agent, so they don't deal with the assets, and then gives the defendant an opportunity to put on an affidavit to explain what they were doing and why they were doing it, and whether the assets are otherwise available or there are other assets that are available so that a freezing order isn't needed. So the very first application is less evidence, but you still have to be as complete and accurate as you can be with both the good and the bad aspects of your claim. But then later there's an opportunity with more information to explore it further in front of the judge.
And is it a consideration when seeking a freezing order if there are moving parts, if it's a trading business, for example, that the directors or owners of the business are permitted to deal in the ordinary course of business, such that money's come in, money goes out to pay normal bills, pay wages, so that the underlying asset is being preserved whilst the proceedings are on foot. So in fact you're protecting value, because the potential here often is that value can be destroyed, and we'll get to undertakings as the damages, and because we want to mitigate against that, the work that needs to go into forming up the orders that a court would listen to whilst preserving the status quo. Can you talk a bit about that, please?
Yeah, absolutely. Well, certainly the freezing orders have really only been used in the last 50 or so years. They're quite a recent development in the court system. And normally the courts won't get involved with an individual's own assets until after there's a judgment and a reason to be using those assets to meet a judgment. But because of this risk that things can be dissipated, the court has now developed this approach. And it's been regarded in the UK as a nuclear weapon of the law. It's often referred to as a drastic remedy that should not be granted lightly. And it's for exactly the reasons you're talking about. You're actually putting a significant restriction on someone's ability to deal with their own property, to run their company, things like that. So what the court will do in granting a freezing order will make sure that there are orders in place to ensure that the ordinary course of business can continue. So if there are household expenses that need to be paid, that there is an amount that is set aside for those household expenses. And that can be quite significant depending on the person and what their normal household expenses might be. And they would put on evidence to say, you've done a temporary order for $5,000 a week, but I actually need $50,000 a week. And if there's good enough evidence, the court will give them permission to spend up to $50,000 a week for their household expenses. And then, of course, legal costs to defend the proceedings. So there will be an amount allowed for that. So even though there is a capped figure, they are still allowed to be spending some of that money to enable them to continue their household and continue running their business. And one of the challenges that creates is particularly in some types of business. So, for example, if you're a property developer and as the liquidator you want to make an application against the property developer's assets, their ordinary course of business is to build properties and sell them. So as soon as they sell them, they are depleting the assets that are potentially available. So the tension there is how much of that is in the ordinary course of business and how much of that may not be, and trying to find a balancing point. And the court can adopt a very flexible approach. So they will listen to the evidence from both sides and try and find a middle ground that works for both sides.
In that case, it does occur to me if settlement needs to occur, for example, to get their secured creditors out, to not impose any covenant defaults, for example, you could agree that the number of settlements go through to clear the secured creditor, for example, and then if the settlements were to continue, those monies be put into a particular account, which are then subject to the freezing order. Is that a possibility?
Absolutely. Yeah, something like that is definitely possible. And that's the advantage once the defendants come back, is they are actually able to explain to the court their situation, show that it's a genuine sale, show they've got secured creditors, and the court, if they're satisfied on that evidence, can make those sort of orders.
Yeah. And is it necessary for there to be public disclosure of these freezing orders so that everyone knows about it, or can it be kept secret, or how does that work?
There's certainly a degree of public exposure because often the asset is not actually held by the defendant themselves. For example, assets are held in bank accounts, held with real estate agents and so forth. So what happens is the order is made and then it is served on those other people. So it's served on the banks, served on real estate agents, so on. And each of those parties are subject to contempt of court proceedings if they allow the proceeds to be dissipated from where they're holding them. And that's a very important aspect in your preparation, is to try and work out exactly what it is that you want held, what the value of it is, because whoever receives that notice has to have a very clear idea of how much and in what form they're supposed to keep money. So is it all the money in bank account ending 123? Is it a certain just cash amount from general accounts? And that can get quite difficult. So that the more particularity you can give, the easier it is for everyone to follow it, and the more likely it is the court will grant that order as well.
Yeah, so that leads us to the types of assets that can be frozen, actually, because it's not then just units that can't be sold, for example, in the case of a property developer, or cash that arises upon settlement. You're now talking about bank accounts, monies held in trust, for example, by solicitors or real estate agents that could end up flowing to the company if certain conditions are met. How do we deal with that in terms of getting as much information to you in our early stages? I guess it's understanding the business, it's doing the best we can, looking at who the parties are and trying to frame that up. It's sort of complicated, isn't it?
It is complicated, and certainly very early in the investigation process that is very difficult to identify. And the onus is on you as the liquidator to convince the court of what the assets are and how they're held and that they are being dissipated. So that can make it quite difficult. And there have certainly been plenty of cases where someone says, well, I'm not telling you what the answer is. You have to work that out for yourself and convince the court.
Yes. Given the onus falls on us to prove to the court that the orders should be made, the evidence needs to be provided by us, obviously. Is there an opportunity in the application, if it's made ex parte, which often it is because of the circumstances we find ourselves in and the risk of dissipation, that we issue subpoenas to the other side to enable us to get that information for the next return date? Is that possible in an application?
That can be tricky because normally an application is filed and dealt with by the court very quickly. And until you have an application on foot, you can't issue subpoenas. So in the limited sense of a subpoena, but depending on the context in which you're operating, for example, the trustee in bankruptcy, for example, has the power to ask the official receiver to issue notices, for example, and you can get information that way, which doesn't require court proceedings. So there are different ways that you can be getting the information. And it may be simply that at that very early stage, you don't have enough evidence, or you have very limited evidence, and you might take the risk of running it to the court and say, I don't have much evidence, but I am concerned because suddenly there are for sale signs on all the director's assets. And the court may, in that situation, grant an order and require the defendant to then list all of their assets and what they're doing. They can do that as well, and that you may start getting some information that way. The balance is, to what extent is a judge going to be satisfied when they don't have much information in front of them in the first place?
So that leads me to the question around the undertaking as to damages. Liquidators and trustees often find themselves in a situation where the very reason they don't have the company is insolvent is because the assets have been taken away from the company. So the liquidators have limited ability to provide an undertaking as to damages when it's the very assets that have been taken from the company which is the subject of proceedings. The liquidators have a bit of a special place in the judicial system because we are officers of the court. Are we the same as others that are required to provide undertakings as to damages in proceedings where we're trying to undertake a public role in a sense?
There are a couple of answers to that, and to some extent it depends on how you approach it. In the general freezing order environment, the person making the application is required to give an undertaking as to damages. And there are issues for the lawyers as well that they should be, even if the judge has forgotten to ask, they should be offering it on behalf of the client. So there is an expectation because of the nature of the application and the impact it can have that you give an undertaking as to damages. It may be that a judge would not require the undertaking as to damages. I wouldn't think that's very common, but in theory you can offer the undertaking, but the judge can decide not to accept it. But the liquidators do have a particular option under Section 1323 of the Corporations Act because that operates like a freezing order, but there is a section or subsection of that act that says that you don't have to give an undertaking as to damages. So that is a way to, and the court's obviously still got to make the ultimate decision on that, but there's no requirement to give an undertaking if it's an application under Section 1323. So that does help.
I see. Okay. Yeah, that's helpful. Yeah. And then in quantifying an undertaking, I guess that's related to the scope of the orders that are being sought, because if you can show that there'd be very limited damage, the business can continue whilst the proceedings are on foot and you're not hampering it, then you can argue that if there was to be an undertaking, that it should be limited in its form.
That is certainly an argument that can be put, although the starting point for the court is that an undertaking should be unlimited. And the reason for that is even though you as the applicant liquidator don't think there are likely to be consequences, the defendant may be able to come forward and say, look, there's all of these other issues that are likely to happen as a result of me having my assets frozen. Like there was a sale or a purchase we were about to go through with. We've signed a contract, you didn't know about it, but if we can't have the cash to complete that purchase, that contract will get cancelled. They then may try and resell to somebody else. If they are selling it, say, for $1 million less than we were willing to pay for it, that's a shortfall, that's damages, that's only arisen because you froze our cash so we couldn't go ahead with the sale. So the liquidator didn't know about that when they made the application. The defendant says, well, this is a real risk, and the court may well say, well, Mr. Liquidator, do you still want to proceed when you have that risk? And then it's a judgment call for the liquidator whether they proceed or not.
Fine. Thank you. Yeah. Let's briefly touch on international issues. There are from time to time assets that are overseas that belong to the entity, which are the subject of our external administration. And I do recall one example where I was appointed receiver of a company by the ACT Supreme Court, where its directors, one of the directors was in Australia, the other one was overseas, and the Australian director became aware of a fund sitting in a bank account in Houston, which belonged to the company, and the order was made here in the ACT Supreme Court that those funds be frozen, and that the liquidator seek, or the receiver seek to repatriate those funds back to Australia. That seemed to work. We didn't have to go that step of trying to enforce the order in the United States, but it seemed to have the effect that where the resident, where one of the directors was here, the other one was overseas, they had heed to the Australian system and the implications for them as a director in Australia should they return, and we did, or were successful in repatriating the money. What other issues have you come across in your work where, or have you been exposed to, where overseas assets could be frozen or potentially repatriated for Australian creditors?
Well, certainly overseas freezing orders or worldwide freezing orders are quite standard. Obviously, you need to show there's a need for it, but they're actually built into the harmonised rules already in the states around Australia. And the reason they work, it's different from actually having a judgment which you need to enforce in another jurisdiction and then try and seize assets in another jurisdiction, because that's attaching to those assets themselves. Because a freezing order operates on the person, as long as there is a connection to Australia, so the court has jurisdiction over that person, the order is actually that the person not dispose of assets up to a certain value, being the claim, the interest and the cost. So let's say $2 million. If they've got $10 million worth of assets, then they can distribute the other $8 million as long as there's still $2 million left. Because it operates in person, it doesn't need to attach to any of the assets that are overseas. So as long as that person is not spending the money or selling the assets or whatever it might be, then it operates because of that connection of the director or the defendant to Australia. So that's why in your situation, because you had a direct connection with the director in Australia, the court was able to make that order and the director was bound to follow it. International orders can be more complex. I haven't personally had to deal with this issue, but I am aware that in the UK, for example, in the past where, for example, there was an asset that was in Switzerland, there used to be, there is a Lugano convention that the UK was a signatory to, and what that meant was effectively it's an international arrangement between the UK and Switzerland. Once the UK left the European Union through Brexit, they were no longer a signatory to that convention, which means in order to make enforcement in Switzerland, they need to have the support of the Swiss authorities and using Swiss legislation. And the legislation that you rely on in Switzerland is more commonly used for the enforcement of final judgments. So the question has arisen as to whether a freezing order, which happens before you get to final judgment, can be applied under this legislation. And if it can't be, then you've got difficulties with enforcement. So you've got an order that's against the individual, but if you need to do something to try and hold the assets themselves, then there could be some international challenges depending on compliance by the other countries.
Thank you. Interesting. Look, finally, challenges. So we've got our freezing order. We're working up our case. We're gathering information on the strength of our claim, what other assets might be available to satisfy, and obviously the other side is going to try and challenge the orders that we've got. What can we expect when we go back next time, and what should we be preparing for in getting to that second hearing on the orders?
Well, I think the first thing is you need to show the urgency of the application or the real risk of dissipation of the assets. So either the defendant or director, whoever it might be, is going to try and show that the asset isn't actually being sold or it's being sold as part of the normal course of business. So that's going to be a challenge. So trying to find evidence that highlights that it's out of the ordinary. Some of that may just be timing. They were served with a demand and the next day they had listed the asset for sale, things like that. That's certainly one aspect. Another aspect is that the assets that are potentially available or the property of the defendant is very broadly defined. Effectively, it's any legal or beneficial interest. But in some cases, the asset will be held in a trust, and a trustee of a trust doesn't only legally holds the asset. They don't have a right to actually use the asset or do anything with it. They hold it for the benefit of the beneficiaries. So you've got to be able to show that there is a beneficial interest that's being held. So, for example, if you have a director who is a beneficiary of a trust, because they're a beneficiary and entitled to get that money, you can get an order against the third party, being the trustee, so that they don't distribute that money. But if you are simply trying to get an order against a company that the director is involved with, that of itself isn't the director's own money, and if it's the director who's the defendant, it's got to be their own assets that you're freezing. So you've got to be very careful to work out who actually owns the assets, who has the beneficial interest in those assets, because they're the only ones that you can actually freeze. So really your first question is, what assets are there, and are they being got rid of, signed, transferred, whatever, and out of the ordinary course? You've got to confirm that those assets are in fact the assets of the defendant or the potential defendant. And you've got to have enough evidence to show that there is a realistic case that you can bring. Now, in the context of the Section 1323 freezing orders that I mentioned before, that's got to relate to a contravention application. So that's usually under the Corporations Act, a breach of directors' duties, an insolvent trading claim. So just because you have a claim against the director, that isn't enough. It's actually got to be a contravention section as well. They're the main things that you need to be looking at. And the other thing, of course, as I said before, is you've got to be fully candid, because the court will squash an order very quickly if you haven't been fully frank with the court about the assets and the issues that are involved.
Thanks, Graeme. I think what I've learned today, which is something I didn't know, it's an order made against the person about what they can and can't do, rather than the actual fund that you're trying to protect and preserve. That's very interesting. Is there anything that we haven't covered in this, Graeme, that you think our listeners might be interested in?
Yeah, there is one thing I'd like to raise. We've been focusing very much on freezing orders themselves, which, as you've just noted, is against the person themselves. And a freezing order in that context must give some space for the defendant for ordinary business costs, living expenses and so on. If you're able to show, though, that the asset has been obtained with company funds, for example, improperly, you may actually have a claim, depending on the circumstances, to recover that asset itself. It's not just a compensation order. And if you can show that you've actually got a claim against the asset itself, you can seek an order to freeze any dealings with that asset. And that's a proprietary remedy, so in relation to the asset. And if you can establish that, you then also don't have to worry about things like living expenses, because it's not an order against the person who needs some money to live on. It's just freezing that asset. And so it's a really useful thing to think about the asset and the kind of process you've got. So if, for example, you have a Black and Friedman style constructive trust where they've stolen the company money and bought an asset with it, there is a claim that you can bring against to recover that land itself. And so you might not just put that in as a freezing order application, you'd actually seek a proprietary injunction to restrain any dealings with that property itself.
That highlights the importance of us conducting our investigations as deeply and broadly as we possibly can, bringing these issues to your attention so that you can decide which are the appropriate orders that need to be made in the circumstances.
Yeah. And that's both the benefit and the challenge that we all face with these kinds of applications.
Indeed. Excellent. Look, that's been great. Thank you so much for your time, Graeme. Very, very much appreciated. This brings us to the end of our podcast today. I hope you've enjoyed this, and I hope our listeners get something out of this. And thank you very much, and look forward to continuing our work with you.
Thanks, Henry. Thanks for inviting me.
Thanks for tuning in to Cathro Partners, The Cut. We hope you've enjoyed today's episode. For more insights, please visit our website, cathropartners.com.au, or find us on LinkedIn.